So we kind of, in order to do the next three cases, we really need to talk about this sort of intervening thing that happens really right as the next three cases are going on. And that's the proposal of the Equal Rights Amendment. So the Equal Rights Amendment was very simple. This is an amendment that would have been added to the Constitution. This is exactly in totality how it would have read. Equality of rights under the law shall not be denied or abridged by the United States or any states on account of sex. That was it. That was the extent of the Equal Rights Amendment. Um, Most amendments these days have absolutely no chance of going anywhere, because it's really hard to think about two-thirds majority of the House and the Senate agreeing on something. Just looking at our current Congress and Congresses in the future, that just seems exceedingly unlikely. Well, the Equal Rights Amendment passed the House and Senate by significant margins. To give you an example, in the House, it was 350 to 15. So overwhelming support for the Equal Rights Amendment. After the House passes it 350 to 15, the Senate doesn't take up the measure. And so in the next Congress, the House passes it again, and the Senate ultimately passes it in 1972. Um, so Congress, by a two-thirds majority, supports the addition of the Equal Rights Amendment to the Constitution. That's amazing in and of itself. The Supreme Court is not an institution that usually we think about as following public opinion, though there are notable examples in which it appears that they did. For example, Brown v. Board of Education, the retrenchment of the integration movement away from busing, and very definitely the Equal Rights Amendment. The Supreme Court seems to take the passage of the Equal Rights Amendment almost as a foregone conclusion. When they see the movement of the House and the Senate overwhelmingly supporting this amendment, it seems to spurn the court into action. And they begin acting very differently than they had previously. But there's an interesting sort of feature that goes on here. In the last section, we talked about civil rights and liberties, and we have the Brown v. Board of Education decision and a number of cases that happen in what we call the Warren Court. And we like to think of, looking back on it, the Warren Court as being an exceedingly liberal court. But in the area of gender rights, it was overwhelmingly conservative. The decisions like Gossett v. Clary are much more akin to the decisions that the Warren Court was making than anything else. And so while we think of the Warren Court as being exceedingly liberal, it wasn't in terms of gender rights, which should seem even more ironic because when we get to the Burger Court, a court which is majority conservative and largely thought of as the first court to sort of single in or to hone in on a conservative movement that takes place between the 1970s and 80s on the United States Supreme Court. This court tends to be fairly liberal in terms of gender rights. In fact, the next three cases that we're going to do happen on the Burger Court. And all of them go in the liberal direction. So this is simply a caveat to say that not everything neatly folds on ideology. More often than not, if you want to predict how the Supreme Court is going to decide a case, you really only need to know who is the president that appointed the judges. But in the case of gender rights, especially in the 1970s and early 80s, that really wasn't a great predictor. And the Berger Court far outstrips the Warren Court in terms of gender rights protections. So let's talk about the Equal Rights Amendment and why it isn't an actual amendment. So we know that both houses of Congress overwhelmingly supported it. So what happened next? Well, very simply, not enough state legislatures ratified the Equal Rights Amendment in order for it to get added to the Constitution. So it dies at the state legislatures. In the initial passage, so after 1972, the states had 7 years in which to ratify the Equal Rights Amendment. 38, what that means is that 38 states had to ratify it by March 1979. So what actually happens? How does this play out? By 1979, there's not enough states. So Congress passes a 3-year extension, giving the states more time to ratify it. We get to the deadline of June 30th, 1982, and the ERA fails. The Equal Rights Amendment does not receive enough support in state legislatures. So why didn't the states ratify it? This is going to sound very familiar. There was an exceedingly strong, vocal conservative opposition that elevated bathrooms as the reason to oppose the Equal Rights Amendment. This should sound shockingly familiar to politics today involving transgendered individuals, because it is exactly the same argument 40 years later. The argument put forward by this strong conservative opposition was that if the Equal Rights Amendment were to pass, based on the language of the Equal Rights Amendment, you could not have segregated bathrooms, meaning bathrooms for men and bathrooms for women. And therefore, all bathrooms would have to be, include everyone. So bathrooms were just bathrooms. I don't need to go through the arguments that the individuals in opposition made, because by the virtue of living in 2021, you all have already heard them. There were arguments made about safety. There were arguments made about everything you can imagine of a sexual nature. And it turns out that, as persuasive as it is now, was equally as persuasive 40 years ago. And so if we really want to get down to the brass tacks and say what defeated the Equal Rights Amendment, it was tying the Equal Rights Amendment to bathrooms. And if that sounds absurd to you, it should. So, let's take a look at what states sucked. The states in pink all ratified it. So Texas ratified the Equal Rights Amendment, along with a large number of other states. Those in blue, so Nevada, Illinois, and Virginia, they ultimately ratified the Equal Rights Amendment, but they did so after the deadline. Then you have a number of states, those in yellow, who ratified the Equal Rights Amendment and then, following the argument that was going on at the time, revoke their ratification. You can see those states in yellow. The states in green did not ultimately ratify it because only one chamber of their legislature voted to ratify it. And then those in blue did not ratify it. You don't really have to be a historian to look at this and see where the opposition came from. This is the South. And one of the reasons why I said in the beginning that we will never get to a point in which we will be ratifying any sort of constitutional amendment, largely for anything, is because it requires 38 states to do so. There were 13 states in the Confederacy. That pushes us past 38. And so I can't see a future, nor can most constitutional scholars, in which a constitutional amendment can be passed in this country. I would not be shocked if in the entirety of your lives you'd never see another constitutional amendment. In fact, you'd never see anyone. You'll live your entire lives without seeing the Constitution amended. Unless something monumentally exogenous happens that spurns the country to behave as one, it's simply not going to take place. The passage of the Equal Rights Amendment in the House was 350 to 15. And this is what stopped it. These southern states were the death of the Equal Rights Amendment. But it turns out, at least for the court, that doesn't matter. Because the court takes up these issues and the court significantly changes the jurisprudence regarding gender issues and doesn't make the Equal Rights Amendment sort of moot, but provides a number of protections from the Constitution that did not exist before the debate surrounding the Equal Rights Amendment started. Questions?